This conference will now be recorded.
Hey everybody, I'm Jodi Kolada with Wellspring Solutions. I hope that you are feeling well, that you're in, as good spirits as you can be, doing okay overall during these real challenging times. Wellspring Solutions is a nonprofit agency that offers home and community-based services to older adults in Guilford County. We do that with our memory care center, our 4 connection sites, which offer group respite, home care, caregiver education, and support. And thanks so much for joining us. We are very fortunate to have Mr. Steve Arrington here virtually to be able to offer this class on wills and trusts and powers of attorney, essentially the nuts and bolts of estate planning for seniors. This was a class we were hoping to offer in person in March. And again, thank you so much to Stephen for being with us. We have about an hour or so, depending upon your questions. And if you can, just please stay muted. And if you happen to be joining us via computer, just please keep your camera feature off because we are recording this and we don't want to violate your privacy. So please continue to keep yourself muted. But if you have a question, he is more than happy to address it during the presentation. So please unmute yourself and then he will reply to your question. So again, thank you so much for joining us. Please, give us some latitude with any technical difficulties and hope you can just enjoy this presentation from the comfort of your own home. So I'm going to turn it over to Steve. And again, thanks so much, everybody, for joining us.
Good morning, folks. My name is Steve Arrington. I'm elder law attorney here in Greensboro. Appreciate you taking your time out this morning to listen to me speak. As Jodi mentioned earlier, I will be talking about various aspects of estate planning for seniors, really for everybody, but the title is Nuts and Bolts of Estate Planning for Seniors. So please feel free, as Jodi mentioned earlier, that if you have a question, please feel free to ask that question. I'll be happy to answer it because normally I find that when one person has a question, you have to excuse me, I'm dealing with allergies. So I will, from time to time, take a swig of water. So please forgive me. But as Jodi mentioned earlier, if you have a question, please ask it. 9 times out of 10, if one person has a question, somebody else does. And it will help, I think, the conversation go a little bit better. I find that live. This is my first video seminar. So again, if anything happens from a technical standpoint or goes a little awry, please forgive us. And hopefully it will be a pleasant experience, positive experience for everybody. So why don't we get started? So again, the title of this is Nuts and Bolts for Estate Planning for Seniors. In my opinion, a sound estate plan is a solid part of financial legacy, healthcare legacy, you name it. So with a well-rounded estate plan, you can make sure not only that you pass away, the things that you own will pass on to your loved ones, but while you're alive, things can be put in place. If you're ever in a position where you can't make decisions for yourself or handle your affairs, that's where power of attorneys come in, which I'll talk about a little bit later. Especially in these times we're going through right now with the COVID virus, right now, about their health and their financial welfare, and that's where, again, if something should happen to you or a loved one, where having a solid estate plan in place can help protect your interest. So let's move forward to the next slide. A typical estate plan, as most of you are probably aware, consists of wills, sometimes trusts, financial power of attorney, you probably heard them called a durable power of attorney, healthcare power of attorney, and declaration of natural death. And I want to make a distinction between living will and I should have probably written last will and testament. There are two different documents. A lot of folks confuse living wills with last will and testaments. The last will and testament controls the disposition of your assets when you pass away. Declaration of natural death, also called a living will, deals with healthcare decisions at the end of life if you are unable to communicate to medical providers and medical decisions need to be made. So I just wanted to make sure. I always talk to folks and they say I have a living will when in fact they have a last will and testament. So I just wanted to clarify the distinction between those two documents. Let's move forward. So the big question is, when I meet folks, how do I know which plan is right for me? In my opinion, no two situations are the same. So while, I have folks routinely ask, why can't I just use LegalZoom, or why can't I just use documents that I found at Office Depot or Staples? As this slide that you're looking at states, there are a number of factors that, need to be considered, when developing an estate plan. So when I meet with folks about the design of their estate plan, what you're looking at are a lot of the questions I ask them, or a lot of my questions are based on what you're looking at right now. The age of the family members. An estate plan for someone my age, I'm in my 50s, versus someone who is in their 30s is a little different. And for instance, if somebody, an estate plan for somebody in their 70s is a little bit different than my plan. I have two young children and I'm married. So my estate plan speaks to my situation as far as the age of my family members. And being an elder law attorney also, so if I have seniors who come to me and want to develop an estate plan, I have to take in consideration, the age of not only the folks that I am preparing a plan for, but those, especially family members that may at some point inherit their assets. Net worth, again, some folks have a lot of money and some folks are doing okay, but necessarily don't have the same net worth as somebody else. So an estate plan, a solid estate plan, should also reflect, the client's net worth. We'll talk about trust a little bit. Trust, the amount of assets or someone's net worth can dictate whether a person should or should not use a trust. So again, someone with a higher net worth, again, trust may make sense for them, but for someone with lower net worth, trust may not make sense for them. The character of their assets, real estate versus cash assets, stock, IRAs, all of those things need to be taken into consideration also when developing an estate plan. Health status of family members is a big one. Again, I'm an elder law attorney, special needs planning attorney. So I do have clients with loved ones who have Alzheimer's or dementia, loved ones with special needs. And so their estate plan should reflect, the different dynamics of, the health of their family members. For instance, if you have a loved one who has special needs and they are relying on the government to help pay for their medical care, a lot of those folks are on Medicaid. So we want to make sure that if they inherit assets from you, that they inherit in such a way that it does not disrupt their ability to possibly get help through Medicaid or some other means-tested program to provide for care and housing. Family dynamics, and that's a big one. I would say last but not least, family dynamics are also a big factor when developing an estate plan. We all like to think that our families are, I will say, functional, not dysfunctional, and that everybody gets along, and that everything will be great forward. But I've been in the 15 years now. I think I've seen enough. But that's almost 15 hours now, and I will say tough, but he's a stranger. And I'm referring to myself as an attorney. But what I press upon the folks who come to see me is that you really need to share, information about your family with the attorney to make sure, that again, the estate plan that you want to, what you want to happen as far as your estate plan come to fruition, and that there are no roadblocks that get in the way of that. Folks unfortunately have substance abuse problems. And what we'll do, you have people with substance abuse problems, creditor problems, and lose them assets in such a way that will either further their addiction, or when they inherit the money, just end up being paid to creditors, and that that your loved ones don't derive any benefit from the inheritance. Again, when I'm asking my prospective clients questions based on what you're seeing here, again, all of these factors help me and help with any attorney come up with a well-rounded, I would almost say holistic plan, again, that will hopefully work for you and not work against you and your family. Moving forward, so I'm also asked a lot, why should anyone do an estate plan? And here are some more factors to consider. Control over the situation. The estate plan, again, should reflect your wishes. So again, the more my clients tell me, the more that I can integrate their wishes into their documents. So in essence, you have control, over, how assets are passed, who makes decisions for you, especially with regards to power of attorney, which we'll talk about here in a little bit also. Again, as I spoke earlier about family dynamics, making sure that, even if you pass away, there's a way to, again, make sure that your loved ones won't wait or that you leave them. You can control that, through reversely, you can control that through the language in a will or a trust. Potential savings and costs. Having a will in will save you money versus not having one. Having a will, when you go through the probate process, having a will is called testate, versus intestate means not having a will, last will and testament. And where it saves you money is in the, with the fact that with intestate, you have to, take time to figure out who your blood heirs are. And so sometimes that can hold up an estate. And as most folks know, a lot of attorneys work by the hour. So if the attorney or whoever is helping you with the probate of your estate is having to take time to track down heirs, and for some of my older clients who are still, and I find it amazing, like 1 of 10 siblings, and 8 of those siblings have passed away. We're having to outline a lot of times, who are the heirs of a person who died without a will. Having a will, you outline again, so that will save you time and money there, versus not having a will and potentially, increasing the cost with regards to having to investigate, who should take. Also, with regards to having a will, you can designate that the executor not be bonded, where in a law it's mandatory that the person be bonded. So there are insurance costs, and the size of your estate will dictate how much in insurance the administrator has to take out. So there's potential savings there. Having power of attorneys, as I mentioned earlier, in my opinion, are a great thing because it could potentially avoid guardianship. If you've ever had a loved one who could not make decisions for themselves, and if you've ever been through a guardian proceeding, the money that you spend on power of attorneys, you will spend much more than that in guardianship action, because at that point you're going to
the reception is terrible. The reception is terrible.
Steve, your audio is currently not on. We are not able to hear you. Yeah, we're keep going. It seems. Yeah, you're cutting in a little bit now.
Can you hear me?
Yes, now I can. It's cutting out again.
Avoid. For what to do on my end. I'm not sure what. Can you hear me?
I heard you say, "Can you hear me?"
Okay. So I'm going to keep talking and just let me know if you can't hear me.
Okay, that's good.
Okay, I apologize, folks. Having technical difficulties with this. So one of the potential savings and costs is with proper planning, reduced tax liability, which right now, because of the tax rules, it's not a big deal. But if you do have significant net worth, you know, it is possible to do an estate plan to help reduce any tax liability when you pass away. If you have IRAs, the rules just changed with regards to tax, the way IRAs are distributed. So again, we want to make sure that your estate plan handles IRAs and 401ks and 403bs in a certain way to make sure that there's no, to reduce any potential tax liability with regards to those assets. Moving forward. Again, control over situation, potential savings and costs, and a big one for me is peace of mind. You know, as an adult child myself, and I've got a parent in a nursing home, and it took us a while to convince my parent to do power of attorneys, but it did save us, you know, potential problems later on because, again, I did not have to go through guardianship. My family did not have to go through guardianship in order to, you know, make sure that my parent was taken care of. So, you know, the documents can also reduce conflict between your families. Simply put, you have it in writing. It can't be disputed what your intent, you know, is with regards to whether it's your will, your power of attorneys, you name it. Putting it in writing, you know, puts it in black and white for everybody involved that this is what you wanted or what you expect at any given time. Next slide. Let's talk about wills. As you know, wills are an excellent way for people to control the disposition of their estate. I am a firm believer that everybody should have wills. A lot of folks tell me they don't have a whole lot in assets and they don't need a will, but if you own a home, or again, if you have heirs, potential heirs that are special needs, if you want to leave something to a grandchild who is under teenage, you know,
We lost you again, Steve.
Years of age, you know, with a solid will in place, again, you know, with regards to their estate. Can you hear me?
Yes, it's cutting in and out.
Am I still out?
That's better.
Let's try something. All right. How's that?
That's better.
Can you hear me? Okay. All right. I apologize, folks. But so anyway, with a will, again, in my opinion, having something in writing can ensure, in most cases, again, that your estate planning wishes are carried out. Next slide. Wills. Primary function is direct how your property is inherited or you know, or who receives your property at passing. Wills can be simple or they can be complex. And in my opinion, that's the beauty of estate planning. You can design your estate plan in many different ways to speak to, your personal situation. Again, it gives you control over who receives your estate versus, and I discussed earlier, testate versus intestate. So again, by having a will in writing, you dictate who gets your estate. If you don't have one, state guidelines will kind of control, who receives your estate. And it's your bloodline only. So I have a lot of blended families that come to see me, and step parent will want a stepchild to inherit. And the only way that that stepchild can inherit is via a last will and testament. Without a will, that stepchild cannot take, they are out. So that is one reason for a lot of families, especially blended families, your second or third marriages, to have a will in place. And as I mentioned before, earlier, having it in writing, having your will, a written will, can prevent family disputes. So if someone says, I should have gotten a particular item, if you put it in writing, again, you make it clear who gets what. Most folks have their children receive everything equally. But there are times where, and I've gotten those calls where a child says, I should get more. But parents' last will and testament says, everything is to be split equally. So, the clerk's office handles that, all asset matters, ensures that the asset among the children, to the person. Moving forward, particular one per. The basic requirement for will: you must be 8 years of age or older. You must be of sound mind. We call this testamentary capacity. The document itself must satisfy the requirements outlined under state North Carolina's law. So you have to be 18. No one under 18 can sign a will or execute a will. And the big one is testamentary capacity. You must be of sound mind and know what you were signing. And the test is that you know what you own for the most part, and you know the objects of your estate, which is your heirs, and you understand that at your passing, your documents will pass to particular heirs. That's generally what's needed to satisfy testamentary capacity. And so again, you must understand and be aware of what you are doing in order for that will to pass probate muster. If you suffer from Alzheimer's, if someone suffers from Alzheimer's or dementia, that does not automatically mean that they cannot execute a will. There are extra steps that someone like myself must take to make sure that my client has testamentary capacity. A lot of times folks say, well, mom had Alzheimer's or dementia when she signed the will. But if an attorney prepared that will for mom, then hopefully the attorney has notes in their file that speaks to what happened during the preparation and execution of the will. So even if a person has dementia or Alzheimer's, the wills will still be honored if, especially an attorney was involved, the attorney took appropriate steps to make sure that their client understood what they were signing. Moving forward. The types of will that are recognized in North Carolina, there are 3 of them. Attested, which is a typed will. That's generally what attorneys prepare. They must, with a attested will, it must be notarized, and there must be 2 disinterested witnesses. Disinterested meaning someone who's not an heir or someone who has a financial interest in your estate should not witness your wills. Holographic, which is a handwritten will, is honored in North Carolina. So if the document is written entirely in your handwriting, and and when you pass away, at least 2 people can attest that the writing is in your handwriting, that they recognize your handwriting. And North Carolina will accept a will written in your own handwriting, and it must simply state, your name, who your heirs are, and what you want them to receive is generally the basics of what's needed for a holographic will. And last but not, well, last, nuncupative, excuse me, difficult word, an oral will are honored in North Carolina, but it's a little tough because it's also known as a deathbed will. So if you, on your last moments of life, say, I want, my estate to go to, so-and-so, whoever that may be, it must be overheard by two people, again, who are disinterested. And as you can imagine, if you're going to try to enforce an oral will, those people will have to show up to the clerk's office. There will be a hearing, and they will have to testify under oath that they both, in fact, heard you utter, the words that you wanted a particular individuals to receive your estate. And if is successful, then the clerk will honor those that oral will. The other component of that is that after making the statement, you have to pass away pretty soon thereafter. I would say within a matter of days. You can't say an oral will and then live another 5 to 6 months. That would be tough to get the clerk to honor that type of will. Usually with a nuncupative will, you have to pass away pretty soon, right after uttering the words. Moving forward, trust, kind of a companion to wills. Trusts are a legal vehicle to manage assets where there is a relationship between the person creating the will and person managing the assets through the trust on behalf of the beneficiary. So trusts are, in essence, are kind of a legal contract, most times with yourself, whereby you outline, how you have decided to manage assets most times during your lifetime. And unlike a will, which is only good when you pass away, trust can be active during your lifetime. But there has to be a specific reason, in my opinion, for using a trust during your lifetime. And again, it has to be in writing. There's no oral, in essence, trust. It has to be in writing in order to be effective. And again, it outlines how you are managing assets, typically during lifetime, but there are also what are called testamentary trusts, that can be set up to handle assets, most notably for loved ones when you pass away. Next slide. Function of trust. Trust can be used to manage assets, as I said, during lifetime or after death. Trust can avoid probate, which provides a level of privacy. That is kind of one of the big points that a lot of folks ask. They don't want to go through probate. They're worried about costs. In my opinion, in North Carolina, the cost of probate is not so high. But if for whatever reason you want a level of privacy, meaning you don't want the world to know what you're leaving your loved ones, that's where a trust might make sense. Wills are public record. You can go down to the clerk's office in any county and look at a will. There's no way that I'm aware of where you can ask the clerk's office to keep a will private. So you can, excuse me, you can wills. You can go see anybody's will at the clerk's office. As I mentioned earlier, trust can help reduce estate taxes. So again, if you have high net worth, it might make sense to do a trust to reduce that liability, especially for a married couple, where trust can be set up to for the first to pass away spouse to take the tax hit, but maybe the surviving spouse, when they pass away, not, to reduce the tax liability. So trust can, in certain situations, help reduce real estate taxes. Trust can be used to place conditions on access to assets. As I mentioned earlier, if you have loved ones with substance abuse problems, or if you have a grandchild who is under 18. You know, I will speak in my personal situation. My wife and I have set, if something's happened to both of us before our boys turn 25, they do not get their inheritance until they are, 25 in one day. We just want to make sure that, they have gone through college or gone in the military, whatever, in order to make, we want to make sure that whatever they receive from us is used in a positive way. And for us, we think being 25, hopefully they've done what they need to, and will be responsible enough to receive any inheritance. So trust, that's the type of conditions that trust can, in essence, impose on access to what you leave by beneficiaries after you pass away. Moving forward. Parties to a trust, grantor settlor. This is the person who creates the trust. So this is the person, when it's all said and done, signs the trust agreement. Again, that outlines how assets will be held by the trust, how they'll be managed. Trustee is a person who manages the trust assets. A lot of living trusts that people use, the grantor and the trustee are the same person. But when when that person passes away, they've named a successor trustee to take over when they pass away, or if they've lost the capacity to manage it themselves. So a trustee has to be named to manage any assets held by a trust. And the beneficiary, this is a person who, as a word says, benefits from the trust. And again, with the living trust, the grantor, trustee, and beneficiary can be all the same person. When we start talking about, and for what I do as an elder law attorney, I do Medicaid compliant trusts. And so sometimes the grantor and the trustee is not the same person, and the beneficiary is not the same person. So again, depending on the type of trust vehicle that's being used, will kind of dictate who sets the trust up, who manages the trust, and who derives the benefit from the trust. Moving forward. Types of trust, as I mentioned before, living trust, that's irrevocable, typically, meaning that during your lifetime, you can undo that trust. And they're very popular in that it gives, the person, the grantor, who sets up a lot of control over the trust, most notably being that if you don't like the trust, or the trust, for whatever reason, is not a viable option, you can revoke it and undo it. And a lot of folks use the living trust, revocable trust, to, again, avoid probate if it makes sense to do so. Moving forward, irrevocable, as the title or the word suggests, it cannot be undone without a lot of headache. Typically, when you set up an irrevocable trust, you are intending that trust to stay in place during your lifetime. Used for creditor protection or tax savings. It's used with Medicaid planning because Medicaid compliant trusts have to be set up in a certain way, and one of the big ones that the government says, one of the factors, it has to be irrevocable, so it cannot be undone short of an order from a judge. Again, depending on a person's situation, a revocable trust might make sense. For those folks who want, a little bit more complicated plan because of creditor issues, tax savings, or even Medicaid eligibility, that's where an irrevocable trust comes in. Testamentary trust, as I mentioned earlier, is a trust that is set up after you die. Typically, those are for members with special needs, or minor children, or again, if you have a loved one who's having personal issues, should not inherit, the money or assets outright. That's where usually you see those integrated into a last will and testament. So there'll be a section in your last will and testament that says trust for the name of the loved one, or trust for grandchildren. That's typically where you see a testamentary trust spring up. Special needs trust, and for those folks who have special needs, Again, since a lot of those folks hear from the government, their trusts have to be set up in a way to, again, that will not interfere with their ability to receive help from the government. Next. Power of attorneys. And in my opinion, this is the most important part of any estate plan. Most folks come in to feel, they want to happen their assets when they pass away, but bigger concern to me is what happens to your assets while you're alive if something should happen to your health. Many of us have seen folks develop Alzheimer's, Parkinson's, dementia, you name it, and lose the ability to handle their own affairs. And in my opinion, that's where the importance of the power of attorneys come into play. And you're still alive, but for whatever reason you can't handle your financial affairs, or you can't make healthcare decisions for yourself. And without them, as I mentioned earlier, is the potential for guardianship arises, which means, again, having to go to the clerk of court and petitioning to have a loved one declared incompetent. Where with attorneys, while you're competent and while you have thought it through, you can name a third party that you trust to make healthcare decisions and manage your assets if necessary. As I mentioned, allow the person, the principal, to appoint a third party called the attorney in fact to make legal decisions, whether it's financial or healthcare, on his or her behalf. Next. Provides a concrete set of instructions, again, in black and white. You outline what powers that attorney in fact to have. It gives you flexibility in that, to done properly, that power of attorney speaks to your situation. I've had a number of Jehovah's Witnesses come to my office who wanted healthcare power of attorneys. If you are a Jehovah's Witness or you know a Jehovah's Witness, they have certain medical restrictions with regards to healthcare. So I've helped them integrate, those religious beliefs into their healthcare power of attorney, again, to make sure that if they can't speak for themselves, that any medical provider that receives a healthcare power of attorney understands that, again, because of religious beliefs, that they cannot receive certain types of medical treatment. And again, another big function, provides protection during periods of incapacity, in that if you, for whatever reason, can't make decisions for yourself, hopefully trust a loved one, whether it's a spouse or an adult child or a friend, step in and can make healthcare decisions for you, hopefully, until you can take over your situation again. However, for a lot of folks, that's not a viable option for them. And again, we want to make sure that the right person is sitting there making decisions for you, while you are incapacitated. Another important function of power of attorneys, actions by the attorney in fact are kept private versus publicly guarded. Everything, especially from a financial standpoint, that a guardian does is reported to the clerk of court. Attorney in fact, unless you designate that the effect keeps that submits accountings to the clerk of court or to the court system,
We've lost you, Steve.
Over by the court system with regards to the management of your assets, like guardianship. So again, are we still out? Hello?
We've lost you.
Can you hear me, Jodi?
Yes.
Oh, how about that?
That's good. Now
Something. I apologize, folks. There must be something in the building interfering with the reception. You can't hear me?
Yes.
All right.
Okay.
All right. Well, we'll keep going. I apologize, folks. Beauty of technology. The types of power of attorney, general power of attorney, also called power of attorney, attorneys.
You're out again.
Controls your finance, you know, saying, are you competent? Oh. 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 Oh.
Your camera's
Let's wiggle
good.
around here. Okay, that's interesting. I wonder why the sound is cutting out and not. Okay, wonder why the camera's. I mean, the sound is cutting out, not the camera. But all right, we'll keep going. The beauty of they revoke or change. They're not permanent. They're only permanent until such time again that you lose capacity to revoke the document, or when you pass away. Power of attorneys are automatically revoked at death. So while you're alive, again, with any estate plan, it can be amended and changed depending on your situation. So, or if an agent does something you don't like, you can change it. Next, healthcare power of attorney. Again, this is a document that if you cannot talk or if you cannot communicate your healthcare wishes to medical providers, a third party can step in and make healthcare decisions for you when you can't. And just like finances, I think it's also important that you consider an appropriate agent. You'll want that agent again to carry out your wishes with regards to healthcare treatment, not what they think is best. So it is, in my opinion, important if you do a healthcare power of attorney that you talk to your proposed agents and make sure that they are going to honor your wishes, especially in the life. I've had that conversation with my family members, and when I asked a certain family member if they would be willing to, if they could, told them things, could they honor that request? And so I had to. I had bypassed the family member. Somebody else told her to show an answer for you. From one.
Sorry, Steve, you're cut out.
Want to make sure again whether it's to or that you.
There you
go. I see that. Can you hear me?
Yes.
Can you hear?
It's cutting in and out. Yeah, I can't hear you.
It must not be me. I think. Do you think? Can you see me?
Yes.
So it must be something with our reception.
I hear you now.
Because if you can see me, not hear me, it must be the. Okay. All right. I apologize, folks. Wonderful technology.
Right. Most people are tuned in, and I think they have the visual. And honestly, this is very valuable information that some folks, obviously, you have to go into an office to receive. So this is very much appreciated. And we already asked for forgiveness in advance about our technical issues. And
yeah.
And yeah. Let's see. I can hear you. Did you need to wrap up that last slide?
Well, as I was just talking about power of attorneys and how important it is to appoint the right person. So again, you want to make sure that whether it's your finances or your healthcare, that you appoint the right person to those affairs. If a lot of folks, if one child is strong with finances, but if you have a child as a medical provider, it might make sense to appoint the child or loved one who's good with money as your financial agent, and the child who's a medical provider to be your healthcare agent, because they understand that. So, excuse me. So again, you want to make sure that you appoint an agent to their strengths, not their weaknesses. Again, because you're not making your decisions, you're appointing this third person, this third party to do that for you. So you have to be really careful, when appointing somebody as your agent. And that plays back into what I mentioned earlier. When I ask a lot of questions and I'm asking tough questions, I'm also asking, my clients before they appoint someone about that person's, the potential for any, in essence, wrongdoing or not following your wishes down the road. I want to know that, and I want to make sure that my client understands that before they sign their documents. Right quick, I want to mention, I earlier mentioned declaration of natural death. Not sure if I let that slide out. But again, if you can't communicate to physicians and they say your time is almost up, in my opinion, it's important to also have that document in place. Like myself, a lot of people don't want to be hooked up to machines, if they're not going to have any quality of life. So it's important to have those directives. That's why it's called a declaration of natural death in writing, also to make sure that if you are worried about being hooked up to machines or receiving treatment and there's just no benefit, that you leave instruction that says, I don't want any extraordinary life prolonging treatment. Just make me comfortable and let me, pass accordingly. So again, I just wanted to make sure that is also that it's important, along with the other documents that I spoke about earlier, that if that's a concern for you, make sure that you put that document in place. So are there any questions that anyone has? And again, I apologize for cutting in and out on you, but I'm happy to take any questions at this point in time.
If anyone has a question, please go ahead and just unmute yourself. And what I'll do, I'm gonna unmute everyone because I'm not sure if you're able to do it. I'm gonna go ahead and unmute, and if anyone has a questions, everyone will be respectful and do one at a time. Okay, some folks are unmuted. Does anyone have a question? Let's see. Also, if let's see, some of you, I'm having trouble unmuting, so you're probably you've muted yourself. So if you have a question, please go ahead and just unmute yourself. And if you don't have, if there are no questions, I'm gonna there I am. Okay. I just want to thank Steve so much. I mean, this, honestly, folks, this, outside of myself doing some videos on some stress management techniques, this is the first video where we partnered with an elder law attorney or with any community partner, and we just value your time and expertise, Steve. And in this time, this is really the only way we're really able to deliver education. So here is, on this last slide, you'll see Steve's contact information, telephone, website, and please also, you can reach out to me if you have questions that you want me to relay to Steve. And please also visit our website at well-springsolutions.org for our upcoming classes. One next week on the 22nd is with the Alzheimer's Association. They're talking about effective communication strategies. We're also offering our 3 monthly support groups virtually. So please make sure to reach out to me, reach out to Steve, and just please stay healthy, stay well, try to keep your spirits up. Steve, anything else that you needed to share?
Not that I can think of. I think I've spoken enough. And I just appreciate, again, thank you, Jodi, for the opportunity to do something other than stare at my computer all day. It's tough on everybody right now with this, with this virus going around, having to sequester ourselves. And but as Jodi mentioned, if you folks ever have any questions, feel free to contact my office, and Hopefully not an emergency, and I'm happy to answer any questions. I am still seeing folks, trying to be careful. But if you need any help, I'm more than happy to help you folks with any situation.
Thank you, Steve. Okay, if nobody has any questions, I'm going to go ahead and end the meeting, and we will just talk soon, everybody. Be well.
Thanks, Jodi.
Again.
Take care, everybody. Be safe.